Hi everyone, happy Data Protection Day and welcome to this Fieldfisher webinar in which we will be discussing the key decisions of the Court of Justice of last year. My name is Tim Vankanet. I'm a partner in the Tech and Data team of Fieldfisher Brussels, and I'm joined by my partner Olivier Proust and our associate Ines Benazouz. To start, I would like to make a few housekeeping comments. First, this webinar is recorded and will be posted as usual on Fieldfisher's YouTube channel, where you can also find the recordings of our other webinars. Secondly, if you have questions, you can type them in the questions box and we will address as many as we can at the end of the webinar. All right, so with that said, what do we have on the menu for you today? I will kick off with the recap of the role of the Court of Justice and provide you with some stats. And then after that, Ines, Olivier, and myself will walk you through the key decisions of 2024, which we have tried to group by theme. And as you can see on the slides, quite a few themes have been addressed in the last year. Let's have a quick look at the role of the Court of Justice in the context of preliminary rulings. Now, most of you will probably be familiar with this, but we thought it was good to do a quick recap nonetheless. So first of all, it's important to bear in mind that claimants do not have a direct access to the Court of Justice in the context of preliminary rulings. The Court of Justice is always caught by a member state court. Or otherwise said, it always starts with a procedure before a national court, in the context of which a debate arises as to how certain EU rules, for instance, the GDPR, have to be interpreted. And if that is not clear, if there is a debate on that, then the national court may decide, and in certain cases even has to decide, to refer a request for interpretation to the Court of Justice. The next step then is for the Court of Justice to analyze the questions in light of EU law, also in light of the Charter of Fundamental Rights, and it will then give an interpretation of how a specific provision of EU law must be interpreted. Now, what is important to bear in mind is that the Court of Justice never provides a final decision with regards to the dispute before the national court. It will simply explain to the national court how it should apply EU law like the GDPR. And based on that preliminary decision, the national court then subsequently adopts its decision on the merits of the case. So it means that a preliminary ruling is binding rather on the referring court. However, and that is really why the Court of Justice plays such an important role in the interpretation of EU data protection law, the decision of the court is also binding on all other national courts before which the same problem is raised. And it's because of the precedent value of its decisions that the Court of Justice plays such a crucial role. With that in mind, let's have a look at some stats. As you can see on this slide, in the early years after the adoption of the GDPR, we've seen a significant hike in the number of data protection referrals. Now, last year, the number of referrals dropped quite a bit. We will see if this trend will continue in 25. Of course, we don't have a crystal ball, but this drop, if confirmed, might suggest that data protection law is coming of age and that there are now fewer GDPR interpretation issues. Contrary to the number of referrals, the number of preliminary decisions continued to increase last year, and we saw an actual record of 28 decisions. Obviously, that is also due to the backlog that the court has. And then finally, one last set that we wanted to share is in relation to the Grand Chamber decisions. It's interesting to note that in the last 2 years, the percentage of those Grand Chamber decisions dropped substantially. If we look at years before, approximately 60% of the decisions were adopted by the Grand Chamber, and the Grand Chamber is actually so it's a lot of people, very smart people, who are looking at a case, and typically they deal with the cases that are of so-called exceptional importance. So again, the drop in Grand Chamber decisions that we saw last year and the year before might suggest that data protection is coming of age and that the types of questions referred are either less complex or have less of a societal impact. Now, all that being said, it goes without saying that having a good understanding of the Court of Justice interpretation of data protection law remains essential for any privacy professional. And with that in mind, let's now have a look at the decisions of last year. I'll hand over to Ines, who will be discussing a couple of decisions that deal with GDPR definitions.
Thank you, Tim. Hi, everyone, and thank you for joining this webinar. We will kick off the session with two decisions issued on the same day relating to GDPR definitions. So the first one relates to the concept of health data in the context of the online sale of pharmacy-only medicinal products. So the Linden Adtech case arises from a dispute between two competing pharmacists over the marketing and sale of pharmacy-only medicinal products via Amazon. When ordering those products online, customers were required to provide information such as their name, delivery address, and details necessary to identify the products. A competing pharmacist claimed that selling pharmacy-only medicines online was an unfair commercial practice because it did not comply with the requirement to obtain customer consent under Article 9.2 of the GDPR, as the data processed qualifies as sensitive data. The National Court referred to the matter to the CJEU, questioning whether the purchase of pharmacy-only medicinal products qualify as health data, even when such products do not require a prescription. It also highlighted that customers may purchase these products for third parties and not for themselves. So in essence, the questions for the CJEU was whether the data of customers obtained during the sales of medicines would constitute health data under the GDPR. So first, regarding the definition of health data, the CJEU reaffirmed a broad interpretation of health data, considering that all personal data which reveal information relating to the past, present, or future health status of a natural person is considered health data. This also includes data relating to the provision of healthcare services. Second, regarding the possibility to identify a natural person, the court has also considered a broad definition of an identifiable person, as it stated that it is sufficient that the person is identified directly or indirectly by reference to an identifier such as a name, an address, an identification number, or by one or more factors specific to the physical, genetic, mental, economic, cultural, or social identity of that natural person. Therefore, even if the medicine is intended for someone other than the customer, it is still possible that this person could be identified. For instance, if the customer provides somebody else's delivery address for the medicine. As a result, the court ruled that any data revealing an individual's health status is considered health data. This includes purchase history data if it can reveal health information by linking a medicinal product, its use, and an identified or identifiable person. The court specified that this also applies to medicinal products which do not require a prescription. Lastly, the court considered that a GDPR infringement can constitute an unfair commercial practice, enabling a controller's competitor to initiate a legal action before a competent court. Moving on to the next decision. In this case, so the Agencia decision, the shareholder of a company requested from the relevant national agency the deletion of her personal data from the company's constitutive instrument published in the National Commercial Register. This document contained various personal data such as her name, her identity card, her address, and her signature. Not all the personal data it contained were required by national or EU law to be published in the commercial register. However, the agency refused to comply with the data subject request, arguing that according to relevant national law, certain information in the constitutive instrument must be published, including the shareholders' information. So first, the court discussed the qualification of the agency under the GDPR. In essence, the referring court asked whether the agency qualify as a recipient or as a controller within the meaning of the GDPR. So first, since the agency received the documents required for the company registration process, the court considered the agency to be a recipient within Article 4.9 of the GDPR. For the purpose of transcribing and storing personal data received in connection with an application process, and by disclosing those data upon request to third parties, the court considered that the agency is a controller within meaning of Article 4.7 of the GDPR. Therefore, the court considered that the agency which received personal data as part of the constitutive instrument is both a recipient and a controller. Second, in relation to the definition of personal data, the CJEU reaffirmed that a handwritten signature is a personal data given that it is generally used to identify a natural person and that it provides evidential value regarding the authenticity of documents. And lastly, regarding the right of erasure, the court affirmed that the data subject has the right to erasure unless the controller can demonstrate overriding legitimate grounds that takes precedence over the person's interests, rights, and freedom. It highlighted in this case that the requirement to preserve the integrity of company documents cannot impose that personal data not required by EU or national law to be kept available to the public in the register. Now moving on to the next section on GDPR principles. So this is the case 446/21, also known as Schrems 3. In this case, it was highlighted that Meta collects user and device related data concerning users' activity both on and off the social network. This data collection extends to third-party websites connected to Facebook via cookies, social plugins, and pixels embedded on those third-party websites in order to track user behavior online. It was revealed that Meta tracked Max Schrems' internet activity using those online trackers, which led to the collection of sensitive data concerning his political opinion and sexual orientation. As a result, Max Schrems received targeted ads relating to certain politicians and to content and advertising relating to content on the gay community. He filed a complaint arguing that Meta had unlawfully processed his sensitive data. Please note that it was highlighted during the discussion that Max Schrems had publicly disclosed his sexual orientation during a panel, but that he had never indicated this information on his Facebook profile. So in essence, the question raised to the court is whether a public statement made by an individual about their sexual orientation authorize an online platform to process additional data about their sexual orientation. In accordance with its established case law, the court first emphasized the importance of determining whether the individual intended, explicitly and by a clear affirmative action, to make the personal data accessible to the general public. In this specific case, the statement made by Max Schrems during the panel discussion was streamed live, published on Facebook, on YouTube, and later released as a podcast. Therefore, the court has considered that this level of dissemination suggests that the individual may have taken action that constitutes making his sexual orientation public as defined under Article 9(2)(e) of the GDPR. That said, the court emphasized that publicly disclosing one's sexual orientation does not automatically permit the processing of other personal data relating thereto. Public disclosure does not constitute consent under Article 9(2)(a) of the GDPR, meaning that Facebook cannot rely solely on such disclosure to justify collecting and combining additional data about the individual's sexual orientation. I will now hand out to Olivier.
Thank you, Ines, and welcome everyone to the webinar. So I will be talking to you about this decision from La Quadrature du Net and others, which has to do with the e-privacy directive, although not about direct electronic marketing and cookies, but rather about the confidentiality of personal data. Now, just to understand and to provide a little bit of background information, as a reminder to everyone, Article 5.1 of the e-privacy directive provides that member states have to ensure the confidentiality of personal data. Also, under Article 15.1 of the e-privacy directive, member states can introduce exceptions to this obligation of confidentiality and can adopt some restrictions where this is necessary, appropriate, and proportionate within a democratic society. For what? Well, for the safeguard of national security, defense, and public security, also for the prevention, investigation, detection, and prosecuting of criminal offenses, or, and this is where it's relevant for our case, for unauthorized use of electronic communication systems. Now, to that end, member states may adopt legislative measures providing for the retention of the data for a limited period of time that is justified on such grounds, on such legal grounds. Now, looking at the French national law, because this case was first initiated in France, well, under the French Intellectual Property Code, members of Adopi, which is an independent public authority whose mission is to protect the works that are covered by copyright against infringements of those rights committed on electronic communication networks, well, the members of Adopi may order electronic communication operators to disclose the identity, the postal address, email address, and telephone number of their subscribers who access their electronic communication services when they have used those services in violation of copyright law. So what was the legal issue here? Well, the applicants claimed that some of the provisions under French law permitted access to connection data of those subscribers of electronic communication services in a disproportionate manner for non-serious copyright offenses committed on the internet, which, according to the applicants, constitutes a violation of the e-privacy directive as well as several provisions of the EU Charter of Fundamental Rights. What did the court rule in this decision? Well, first, the court ruled that Article 51 of the e-privacy directive does not preclude national law from authorizing a public authority in charge of protecting copyright and identifying copyright infringements committed on the internet from accessing the civil identity data associated with the IP addresses of those internet users that are withheld by the providers of the publicly available electronic communication services. However, that must meet several conditions. The first condition is that there must be some technical arrangements put in place. What does that mean, and what are those technical arrangements? Well, those data must be retained in conditions that will ensure that it is not possible to draw any conclusions about the private life of the IP address holders. And here the court goes even into the detail of saying that it is prohibited to establish, for example, detailed profiles of the internet users. So in other words, profiling users on the basis of that civil identity data is not permitted. Now, how and by what technical means? Well, by imposing on the providers of electronic communication services an obligation to ensure a watertight separation, and those are the terms used by the court, a watertight separation of the different categories of personal data, such as the civil identity, the IP addresses, and traffic location data, in such a way that it is not possible to combine the different data sets while it is being retained. So we see here how on this first condition, the court imposes indirectly an obligation on the providers of public electronic communication services. The second condition to process the civil identity data is a limited purpose, strictly speaking, to identify the IP address holders who have committed copyright infringements. In other words, the public authority's access to such data must serve exclusively the purpose to identify the person who is suspected of having committed such a copyright infringement, and such access cannot allow to draw precise conclusions about the private life of that IP address holder. In particular, what this means is that the agents of the public authority are prohibited from disclosing any information about the content of the files that they are working on, except if it is to refer a matter to public prosecution. They are also prohibited from tracking the clickstream of those IP address holders, and they are prohibited from using the IP addresses for any purpose other than to identify their holders with a view to taking measures against them. And then lastly, the third condition is that there must be a system of checks and balances put in place. The possibility for agents of those public authorities to link the data with existing files in cases where the same person again repeats a copyright infringement must be reviewed by a court or administrative body before any such linking takes place, to ensure that such linking does not allow to draw conclusions about the person's private life. And then finally, the data processing system that is used by the public authority must be subject at regular intervals to a review by an independent body acting as a third party. And this is intended to verify the integrity of the system, including the effective safeguards against risks of abusive or unlawful access to the data, and also the effectiveness and reliability of the system that is put in place by that public authority. So what this means here is we see how the court authorizes and confirms that under national law, the exceptions to the general obligation of maintaining the confidentiality of personal data is permitted, but it does impose on public authorities that are processing civil identity data to put in place certain measures and to comply with very strict rules in order to protect the private life of those individuals. If we move on to the next case. So this is another interesting case concerning KNLTB, which is a sports federation in the Netherlands whose members are tennis associations. And KNLTB, of course, was collecting the personal data of the members of those tennis associations, but was also disclosing the personal data of its members to two of its sponsors, one being Sports Shops Direct, a company that sells sports products, and they were given access to names, addresses, and the domicile of its members in order to, for the purpose of posting leaflets, and those leaflets contained offers on the products that the company was selling. And the other disclosure was to the Dutch lottery organization, the largest provider of games of chance and casino games in the Netherlands. Here again, they had access to names, addresses, but also date of birth, telephone numbers and mobile numbers and email addresses. And they were using this data for the purpose of conducting telemarketing campaigns. Now, KNLTB had not collected the consent of its members in order to do that, and was relying instead on its legitimate interest. And here, the Dutch Data Protection Authority imposed a fine of 525,000 euro on the grounds that the legitimate interest within the meaning of Article 6.1f of the GDPR can only be the interests that are enshrined and determined by law. So the question that was put to the Court of Justice was, how should the legitimate interest be interpreted, and are they interests that exclusively pertain to the law, or can any interest be a legitimate interest provided that it is not in breach of the law? Here the court answered in three parts. First, it reminds the three cumulative conditions on which controllers can rely when they are processing the personal data for the pursuit of their legitimate interests. And in order for this to be done in a lawful manner, well, the first condition is that there must be a legitimate interest and the controller is pursuing this legitimate interest. Second, the need to process the personal data for the purposes of the legitimate interests in question. And third, the interests or fundamental rights of the data subjects must not take precedence over the legitimate interests of the controller. So looking at these three conditions in more detail, well, on the first condition, the pursuit of the legitimate interest, the court says that in the absence of a definition of that concept in the GDPR, a wide range of interests is capable of being regarded as legitimate. It also says, and this is where it's interesting, that the EU legislator did not require that the interest pursued by the controller be provided for by law in order for the processing to be legitimate. Nonetheless, the alleged legitimate interest must be lawful. So not necessarily provided by law, but it must be lawful. And how did it rule on this first condition? Well, first it recalled its previous case law from the Google Spain decision of 2014, in which the court had not ruled out the possibility that the commercial interest of the controller, which consists in promoting and the sale of advertising space for marketing purposes, may be regarded as a legitimate interest. In the given case, the commercial interest of the controller may therefore constitute a legitimate interest, provided that it is not contrary to the law. On the second condition, the necessity, the court says that the legitimate interest pursued cannot reasonably be achieved just as effectively by other means less restrictive of the fundamental rights and freedoms of the data subjects. But also the court interestingly adds that the condition relating to the need for processing must be examined in conjunction with the data minimization principle. And in the given case, the court found that it would be possible for a sports federation that wishes to disclose its members' data to third parties to inform its members beforehand and to ask them whether they wanted their data to be transmitted to those third parties for advertising or marketing purposes. This would have made it possible to comply with the data minimization principle and therefore to limit the disclosure of data to what is relevant and necessary. In other words, only to those data subjects who have given their consent. So on this second condition, it found that this, in other words, the application of the data minimization principle was not met. And on the third condition, the balancing of interests, well, it says that that condition entails a balancing of the opposing rights and interests at issue, and this depends in principle on the specific circumstances of each particular case. So therefore, here it was important to assess whether the members could reasonably expect their data to be disclosed to third parties for advertising and marketing purposes. And in particular, the court found that while the transmission of data to a provider of games of chances and casino games in the given context was legitimate, it is not characterized by a relevant and appropriate relationship between the data subjects and the controller. Therefore, the court found that such processing could have a harmful effect on the members of the tennis associations, given the risk of gambling addiction. You'll note that, in fact, the court highlighted this point with respect to the casino, the provider of games of casino and games of chance. It did not provide the same thing or the same ruler with respect to the company that was selling sports products. So in conclusion, in this decision, it found that the processing of personal data in order to satisfy a commercial interest of the controller could be regarded as necessary for the purposes of the legitimate interests of that controller, on the condition that the processing was strictly necessary and in light of the relevant circumstances that the interests and fundamental rights of the members did not override that legitimate interest of the company. In conclusion, while that provision does not require that such an interest be determined by law, it did require that the alleged legitimate interest be lawful. So an interesting clarification on what constitutes a legitimate interest and how the necessity for it to be lawful is interpreted by the court here. Moving on to the next case, and I'll be a little bit more brief on this one. Essentially here, without going into the details of the facts, the court gave some clarification on the application of Article 6.1b, which is relying on the contractual necessity for the performance of a contract as the legal basis for the process and activity, and also on compliance with a legal obligation under Article 6.1c. The court first recalls its previous case law and refers here to the Meta decision issued on the 4th of July 2023, where it had found that in order for the processing of personal data to be regarded as necessary for the performance of a contract, it must be objectively indispensable for a purpose that is integral to the contractual obligation intended for the data subject. The controller must therefore be able to demonstrate how the subject matter of the contract cannot be achieved if the processing in question does not occur. And this decisive factor is that the processing of personal data must be essential for the proper performance of that contract concluded between the controller and the data subject, and therefore there are no workable, less intrusive alternatives. Now, on the ruling in this particular decision, and looking first on the reliance on the contractual necessity as the legal basis for the processing, the court found that the processing of personal data, which consists in disclosing, in this particular case, disclosing at the request of a partner of an investment fund, information on all the partners with indirect shareholdings in that fund for the purpose of contacting them and negotiating the purchase of their shares. Such a disclosure may be regarded as being necessary for the performance of the contract pursuant to which those partners have purchased such shareholdings, but only on condition that that processing is objectively indispensable for a purpose that is integral to the contractual obligation intended for those same partners, with the result that the main subject matter of the contract could not be achieved if that processing were not to occur. In the given case, the disclosure of the information of those partners in the investment fund could not be regarded, according to the court, as being necessary for the performance of a contract within the meaning of Article 6.1b. Why? Because the contract in question on which the acquisition of the shareholding was based explicitly prohibited the disclosure of the data to other shareholders. So in other words, if you are relying on the clauses of a contract, but that contract stipulates that the disclosure of data is prohibited, you cannot rely on the contractual necessity as a legal basis for disclosing that data to other parties. On the second point that was ruled in this decision on the compliance with applicable laws as the legal ground for processing, the court here found that the controllers can rely on national case law as a legal ground for processing personal data in compliance with Article 6.3b. A very interesting interpretation, because privacy professionals often refer to this as a law or a statute. Here the court says, well, it's possible to rely on national case law. However, that case law must be clear and precise, and its application must be foreseeable by those persons who are subject to it. So an interesting development and interpretation of Article 6.1c, which is the compliance with the legal obligation as the legal basis for processing the personal data. With that, I will hand it back to Tim, I believe.
Yes, indeed. Thank you, Olivier. I will move us on now to compensation. There's actually a lot of decisions that were dealt with last year that dealt with remedies in general. I'll start with right to compensation, but we'll also talk about DPA enforcement and even representative actions. And I think it's fair to say that right to compensation was certainly one of the hot topics of last year. You will probably know that a data subject who suffered material or non-material damage can claim compensation from either the controller or the processor who infringed the GDPR. That's laid down in Article 82. And we actually had in 2023 already the Austrian Post decision in which the Court of Justice had clarified that the mere infringement of a provision of the GDPR in itself does not confer a right to compensation. So in other words, if a data subject wants to claim compensation, it must establish the existence of its damage, so provide a proof of the damage, and also a causal nexus with the actual infringement. Now, with that in mind, there were apparently still a lot of questions that subsisted, especially regarding the concept of non-material damages. We've seen that in 2024, the Court of Justice adopted no less than 6 decisions that dealt with this concept. And I will focus on 3 of those to summarize the main takeaways of those decisions. And so the first one that I will discuss is this Saturn Electro case, which dealt with a situation where a retailer had handed over a contract that contained personal data to the wrong customer who was standing in the queue at the counter in the shop. Now, that employee had quickly discovered the mistake and had rectified that almost instantly. But that did not stop the data subject from claiming compensation for non-material damages on account of the fact that Saturn Electro's employee made a mistake and that there was a risk of loss of control of its data. And so a national court had asked several questions to the Court of Justice, and in this case, the court essentially decided that, first of all, the unintentional transmission of data to an unauthorized third party, so this other customer that was standing in the queue, that does not automatically mean that the controller infringed the obligation to implement appropriate technical and organizational measures. I think that should not come as a surprise, but it's always helpful if these kind of things are being confirmed at the level of the Court of Justice. Secondly, and probably more importantly, the court clarified that the purpose of the right to compensation is to compensate the data subject for the actual damage it suffered. So compensation is not a sanction. It must not serve a punitive or deterrent purpose. Obviously, DPAs play a different role. When they will note that there is an infringement of the GDPR, they have that power to punish and to impose sanctions. But in the context of the right to compensation, that should not come into play. And then finally, the court also decided that a data subject who is claiming compensation must provide evidence of the actual damage. The hypothetical risk of misuse of data in itself is not enough to trigger the right to compensation. They must be able to show that there is actual damage that they suffered. So that was the first case. And then second case was the scalable capital case, where the underlying facts were quite similar. It was also unauthorized disclosure of data. And in that decision, the court expanded on its interpretation by adding a number of additional clarifications. First of all, it recalled the fact that Article 82 of the GDPR intends to compensate for the damage suffered, but then it added that the amount of damages cannot be determined taking into consideration the severity of the infringement or the fact that the infringement was intentional. So the only thing that matters is, has damage been suffered? And if damage is suffered, that should result in compensation, full compensation. But whether or not the infringement was a severe infringement, whether or not the infringement was intentional, does not come into play when determining the amount of the compensation. Now, in the context of non-material damage, of course, there's always a lot of discussion on how you evaluate that damage. And often what we see is that somehow symbolic amount is awarded. Just recently in the Bindel decision that the General Court adopted earlier this month, we saw that an amount of 400 euros was awarded for non-material damage. And so the scalable capital decision also looked at how that should be regarded. And the Court of Justice essentially took the view that, first of all, and quite interestingly, one should not presume that non-material damage, for instance, emotional distress, is by its nature less significant than physical injury. So that's the first important thing to bear in mind. But added to the court, if the non-material damage is not serious, so sometimes it might be serious, but sometimes the non-material damage will not be serious. And if it is not serious, then it can be acceptable to award minimal compensation. But that minimal compensation should offer full compensation for the damage suffered. I think those are very sound principles, but in practice, of course, the real question is, what is full compensation if the damage is non-material? That is always, a bit vague, of course. But so helpful clarifications for national courts to apply when they are dealing with these non-material compensation requests. And then finally, also helpful, the court decided that in situations where there is theft of personal data, the data subject may suffer non-material damage, like emotional distress, even if that theft did not subsequently lead to the identity theft or fraud. So even if the loss of data doesn't result in actual fraudulent use of that data, that still might trigger the occurrence of non-material damage. And then we had a last case on compensation, a case with a name that I will not try to pronounce. But in that case, the data subject was seeking compensation for emotional distress and reputational loss, which was caused by unlawful processing of its data. And actually, in this case, the court took an original, but certainly pragmatic stance. And I'm sure that many organizations will welcome that decision. So first of all, the court recalled that the right to compensation must result in full compensation of the damage, but then it went on to acknowledge that in certain situations where the non-material damage is not serious, an apology may actually also constitute full compensation. And I think that is really helpful to bear in mind. Organizations that suffer personal data breaches, there is always this dispute typically between the client-facing people and the lawyers or the DPOs on whether or not an apology should be offered in the notification to the data subject. Well, actually, with this decision, you could actually use that in your advantage, because in certain situations, that apology might already suffice and you would no longer be required to pay an actual monetary compensation to the data subject. Now, in the first decision on compensation, I mentioned that a court may not award punitive damages, so higher compensation than the actual damage. In this third decision, the court also confirmed that a court may not award lower compensation than the actual damages, even in situations where the controller can avail of mitigating factors. We all know that mitigating factors are often invoked by controls or processors when they are facing a data protection enforcement procedure to get a lower administrative fine, and it works in those situations, but it will have no relevance in the context of determining the amount of compensation. So that was compensation. Let's have a look at a decision that dealt with representation of data subjects. The Meta Platforms Ireland case, this was a German consumer protection body that requested an injunction alleging that Meta had failed to provide clear and comprehensive information before obtaining data subjects' consent. Now, this German body acted on its own initiative, so it hadn't been mandated specifically by one or more data subjects. And first of all, in this case, the Court of Justice has confirmed that such legal action, without having been mandated, is admissible if member state law expressly conferred the right to such a body to act without mandate. And this is indeed the case in Germany. So in Germany, these representative bodies can act without a formal mandate, but in other member states, for instance, Belgium, that provision has not been adopted. It was an optional provision in Article 80 of the GDPR. And so in those other member states, potentially this action would not have been admissible. The second question in this case was actually very interesting. So to be admissible, the representative body had to assert that the rights of a data subject were infringed as a result of the processing. Now, in the case at hand, this representative body alleged that Meta had not provided transparent information before data subjects were consenting to the processing. So one might argue that the infringement occurred before the processing and that the rights of the data subjects were not infringed as a result of the processing. Now, the Court of Justice did not follow that interpretation. It actually did a very detailed analysis of the objectives of the GDPR, which in light of the Charter of Fundamental Rights are there to ensure a high level of data protection. And it concluded that in the case at hand, the infringement of the right to information does qualify as an infringement that results from the processing. And so therefore, the representative body was entitled to initiate its injunction proceeding. So then I will take us to two decisions that deal with data protection enforcement. The first one is the Land Hessen decision, a German decision where a data subject had taken action against a data protection authority, actually. So this data subject had filed a complaint following a data breach, and after an investigation, the data protection authority had decided not to impose an administrative fine on the controller. And in doing so, it had taken into account some of the measures that the controller had taken to remedy the consequences of the breach after it had become aware of that breach. Now, in this decision, the Court of Justice decided that the GDPR indeed does leave a margin of discretion to data protection authorities in terms of choosing the corrective measures they impose. But, says the Court of Justice, that discretion is not without limitations. Data protection authorities must ensure that a consistent and high level of data protection is ensured. And so in deciding which measure to impose or whether to impose a corrective measure, they should always bear in mind that objective. And having done the analysis in the case at hand, the Court of Justice then decided that in case of a data breach, a data protection authority is not obliged to always impose an administrative sanction. If it can argue and justify that that would not be appropriate, necessary, or proportionate, then it could decide not to do that. And so, in fact, what this decision does, and which I think is very welcome for both data protection authorities, but also for controls and processors, it sort of confirms that data protection authorities have the right, in light of their heavy caseloads, to decide on certain decisions and in relation to certain cases and certain complaints they've received, not to take action because that would not be appropriate or necessary or proportionate to remedy the infringement. The second case on DPA enforcement deals with the question whether a data protection authority may order the erasure of unlawfully processed data. And you would say, well, yes, of course. But it went on a little bit. Can it order that erasure even if the data subject itself had not asked for it? And if we look at the corrective powers of data protection authorities in Article 58, paragraph 2, we will see the little d, which states that a data protection authority has the power to order a controller or a processor to bring their processing operations into compliance with the GDPR. And so erasure of unlawfully processed data could obviously be part of that. Now, in this case, some of the parties to the case were arguing that ordering the erasure without the data subject having requested this might actually negatively impact the latter, and that erasure should only be ordered if the data subject had actually made the request. And so the Court of Justice took the view that a data protection authority may order the erasure of unlawfully processed data, even absent that request. because it can simply not be accepted that a controller would be allowed to continue to process data unlawfully. So if it has been established that a certain processing activity is unlawful, and even if the data subject is not opposing to it, or maybe potentially not aware of it, and therefore has not requested the erasure of that data, well, even in those cases, data protection authorities can order that erasure. A decision which I think makes a lot of sense. And with that, we have arrived at actually the last decision that we want to cover in today's webinar, and it's a very clear case of last but not least. It's the IAB Europe case, probably one of the most high-profile cases with potentially huge impacts on the Adtech world. Now, a lot has already been said on this decision, and I think we could easily fill a whole webinar analyzing this, and obviously that's not the purpose of today. So all I will say today is that the CJEU has confirmed, first of all, that the so-called TC string, which is a string of a combination of letters and characters, which documents the consent choices of a website visitor, that TC string does constitute personal data. And secondly, the court decided that IAB Europe and website operators who implement IAB Europe's TCF framework for serving online advertisements, that they are joint controllers for the processing activities that relate to the gathering of consents. And that is regardless of the fact that IAB Europe does not have access to the actual data. Now, this is obviously a high profile and one might even say controversial case, the IAB Europe case, but I think personally speaking that the Court of Justice conclusion here in relation to these two elements don't really come as a surprise, especially if we look at previous decisions on joint controllership. We have had the Fashion ID decision, the Jehovah Witnesses decisions, where similar conclusions were drawn in relation to different setups, but where the way in which two parties were doing stuff together was being rolled out in pretty much the same way. I think this decision obviously is far from the end of the debate, and the real debate is whether the TCF framework that IAB Europe has created and that is being used on so many websites for online targeted advertisement, whether that is lawful. That debate has not been ended. No question was asked on that specifically to the Court of Justice. And so the case is now back in front of the Brussels Court of Appeal, who will need to decide on the fate of the TCF framework. We will, I'm sure, all hear about how that ends probably the minute after the Court of Appeal publishes its decision. But so an interesting and important intermediate step, I would say, in this long-standing fight between initially the Belgian Data Protection Authority and some other authorities against IAB Europe. And so with that, we have come to the end of this webinar. As we have seen throughout 2024, the court has continued to shape the form of data protection law in the EU. And no doubt the Court of Justice will continue to do that in 2025. We already have the first 3 referrals of 25 on the books. And there are approximately 40 referrals still pending before the court. So there is still a lot of clarification that we may expect in coming months. And obviously the Fieldfisher Tech and Data team will continue to monitor these decisions and will keep you informed of important new decisions. We hope with the 3 of us that you found this webinar interesting. If you have any questions, now is the time to ask them. I'm gonna have a quick look at the questions box to see if any have come in so far. I don't see any at the moment, but if you have a burning question, do fire them to us. We'll be happy to take them. Okay, I see no questions are coming in, so I'm assuming that the clarifications that the courts provided and which we have tried to translate for you were all clear. So we will wrap it up here. Thank you again for attending this webinar, and stay in touch. Have a look at our YouTube privacy channel. It has a lot of webinars on other data related, but also AI and Data Act, and you name it. There's a lot of valuable information there. Thank you, and talk to you soon. Bye.